Good morning, Your Honor. May it please the Court.
Do you want to divide your time with anybody? Or?
Yes, Your Honor. I'd like to allocate 3 minutes for myself on behalf of the mother of B.A., 2 minutes for Mr. Berger on behalf of the Regional Counsel's Office representing D.M., the father, and Mr. Rodriguez from FIU is going to be arguing for 3 minutes on behalf of A.M., minor child.
And then 1 minute for rebuttal.
And I think that was just 2 minutes for rebuttal, Your Honor. Okay. Your Honor, this is a TPR case, and on behalf of the mother of B.A., our argument is pretty straightforward and pretty simple. The question is whether or not the department provided reasonable, meaningful, and diligent services to the mother. This case came in November. The case manager admitted on the stand that the mother did not receive any appropriate services for the first 3 months of the case plan, up until February 2010. In October of 2010, they changed the goal to adoption some 8 months later and filed a petition for termination of parental rights. So the question before this Court is very simple, whether or not those efforts by the department in those 8 months rise to the level of meaningful and diligent. The testimony was that the mother completed her parenting, she completed her psychological evaluation, she completed everything but her domestic violence.
And the individual therapy.
And the individual therapy, correct, which was actually melded in at the end as being part of domestic violence because the way they did this was so convoluted.
Yeah, I didn't get the impression that the failure to, although it was a finding by the trial court, I didn't get the impression that that was really the focal point of the trial court's ruling, the failure to complete the courses. I got the impression that the trial court was more concerned about the mother's lack of insight and inability to protect the children if they were returned to her care, especially in light of the fact that she had a continued relationship with the father, which is more problematic here.
And I understand. I don't believe there's clear and convincing evidence that there was a continuing relationship. The only thing I saw in the record that I recall from trial was a statement by the case manager, Ms. Persano, that they were concerned that she was continuing a relationship with the father. No one testified that they'd seen them together, that there was a continuing relationship. So I would argue to the court that, and I don't believe it's clear in the ruling that, in fact, that was the basis.
There was a finding by the trial court, but you're saying there was insufficient evidence to support that finding.
I believe the only evidence is that hearsay statement by Ms. Persano. Moreover, I believe that if you don't give, I think the problem here is where the department doesn't make meaningful and diligent efforts to give somebody their services, they can't come back and terminate for either 39806.1E1 or 2 material breach, because how can you say the person is not going to reach a successful conclusion if you haven't given them the services they require to amend the problem, to cure the problem they had? In this case, this was all fits and starts. This mother was, the only thing this came in on was domestic violence. The mother was a victim. First, they sent her to a perpetrators class for 3 months. Then they sent her to another class for a period of, I believe, three classes. Then they changed it again, and the case manager testified that the mother completed her initial course. On page 151, she says the mother
completed the domestic violence counseling, but the testimony was that she gained no insight from the counseling, that she didn't seem to understand what her duty was and how she could protect the children.
And they offered her continuing services, what she needed to continue on the services. But what they did was they didn't make that referral until the time of termination. The referral and the testimony by Ms. Persano was that they made the referral in October of 2010. The mother, the adoption case plan was adopted on October 13th, no pro tunc to October 8th, and the termination was filed that same month. So what I'm arguing to this court was the department did
not...
Didn't
they make an initial referral that she was not attending, and then she said she wanted to go to her own therapist, so they then approved it, and she started off and didn't finish that counseling at the time of the hearing.
Your Honor, the standard here is clear and convincing evidence. I was at the trial, and I've read the record, and I don't think it's clear to anybody how it worked. It's very unclear and to me, very murky as to what exactly occurred, because the testimony was that she did 3 classes here, 3 classes there. They came to an agreement. She completed, the testimony was by the case manager, she completed her initial time frame. And they continued that time frame, and because she was already in services with, and I apologize, I can't remember the name of the agency, they referred her back there, but that referral was in October of 2010, simultaneous with their filing the petition for termination of parental rights.
You've used up only 3 minutes.
I would ask, based on these grounds, that they did not provide meaningful and diligent services to this mother, that this should be reversed and remanded.
Thank you.
May it please the Court, Dennis Porter from Regional Counsel. On behalf of the father DM, I'll try to work less than the time, so we'll come in.
How much is your time again? 2 minutes?
I'll do it in one. The issue for the father before this Court is that he was given a contract. The Department of Children and Families did not fulfill the contract. He was supposed to do, I think it was 4 or 6 services. He did 3 or 4 of them. But he did not do anger management or individual therapy. And when it came up at trial, the social worker said, we didn't think it was worth giving it to him, and he should pay for it. And he was indigent, could not afford indigent.
Well, I'm not sure that was testimony. They did send him, refer him to anger management, but in fact, that was really the basis of his problem, is that he had this deep-seated anger, and that's what the therapists were really concerned about, especially in light of the domestic violence and the injuries on the knees and so on. Anger was a real issue in this case. He said that he was unemployed, so they reduced the cost in half and asked for verification of his unemployment, which he failed to produce. Is that incorrect?
It's sometimes hard to prove a negative. That's probably, I only have the information that he was indigent, legally indigent, having regional counsel as attorney, and I have no information that ever came in showing that he was employed.
What was the cost of the program as reduced?
I think it started out at $75 a week, I think, or $70 to $75, and even half of that, or whatever it would be, $35, $40 a week, whatever it would be. I can't testify, but that's what it would be. And we're asking that this be reversed, and I adopt all argument of counsel.
Thank you, counsel.
Good morning, Your Honors, and may it please the Court. My name is Ricardo Jose Rodriguez Santana. I'm a staff attorney at the FIU College of Law Clinical Programs, and I, along with Laverne Pigney, represent the minor child AM. Your Honors, this case is about a perfect storm of failures, 2 of which specifically apply to the minor child AM. Firstly, the trial court failed to determine whether each child had the intelligence, understanding, and experience to express a preference as required by Florida Statute 39.810, subsection 10. And secondly, the guardian ad litem failed to disclose to the court a conflict of interest between each child's distinct representation.
Did the trial court specifically find in the order that the children are smart, adaptable, well-adjusted? Doesn't that, and then goes on to determine what's in the best interest, and does address the fact of what this child's preference was, which was to return to the mother?
It does, Your Honor, but in the trial, or in the order, it specifically states that they assume the children do want to return to their mother. It does not specifically state whether it's that they're understanding what the children want and that they want to take into account.
He made a finding that this child is smart, is intelligent, and the child wants to return to the mother. What more did the trial court have to do?
The trial court needed to take that into account into their determination of what was in the manifest best interest of the child.
Didn't the trial court do that by putting it in the order?
We would submit that it did not, Your Honor, because it was merely assuming that they want to return to the mother as opposed to making a finding of what her expressed wishes were. The Florida statute requires that they take into consideration what the children want as part of the termination of parental rights proceedings. We submit that the trial court did not, because it merely assumed, and it made a passing reference in the trial court that the children, that AM specifically wanted to return home to mom. Based on this, we believe that that the court should have taken into account AM's expressed wishes, and if they would have done so, the outcome of this trial may have been different. Moving to my second failure, Your Honor. The statewide guardian ad litem office standards of operation specifically states that the GAL program shall request discharge from a case because of conflicts arising from representation of multiple parties. In this instance, one guardian ad litem was appointed to represent all three children with varying backgrounds, varying developmental differences, and varying wishes. Specifically, the son in the case expressed a desire not to be returned home. But A.M. did state in the trial court, and the guardian ad litem disclosed, that she did want to return home with mom. Based on this, we ask that the court overrule the TPR.
Thank you very much. You're going to divide your time.
Your Honor, I'm going to take 1 minute to address the final argument of counsel with respect to the guardian ad litem program. Karla Perkins for the department will address the other argument. So, good morning, Hillary Kambour for the guardian ad litem program. Your Honor, there was no conflict in the guardian ad litem position, representation, advocacy in this case. Counsel confuses the role of the guardian ad litem with the role of an attorney ad litem, or with most attorneys who advocate for the express position of their client. That is not what the guardian ad litem program does, or our guardians in general do. They represent the manifest best interest of the children. They take into account many, many factors in determining what is in the manifest best interest of the child. One of those factors is, of course, their express wishes, which is what this guardian did. Now, the fact that these children have differing express wishes does not mean necessarily that they have differing best interest determinations as determined by the guardian ad litem.
Now, I am not concerned with the conflict issue, but I would like you to just briefly address the trial court's findings, because when you do read the order, it does seem to be very general as it relates to AM. It says the children in general are intelligent, and it says the trial court assumes that other than MM, the children want to return to the mother. That does not really tell me that the trial court considered AM's real desire to return to the mother, and her, whether the trial court really weighed that factor in making the determination as to what's in the best interest of AM.
Your Honor, I believe it does. The trial court could have been more explicit. Of course, he could have said precisely what the guardian said, which was that MM doesn't want to go home or see his parents, and AM does, and that the other child...
AM is the oldest of the children, so the most mature of the three to make that decision.
And the guardian represented that she was bright, and as Your Honor said. I believe although the trial court could have been more explicit, the gravamen of the issue is that the court recognized that even though the child wants to go home, it's not safe. And we have, in my brief, I believe, a string site where...
That's the other question I want to ask, and I was really going to ask about the safety of the home. And my concern is what evidence was there that the mother and the father are still involved with each other, and that the children, or AM, would be at risk if she was returned to the mother's household as to having the father have access to her and to harm her.
And Your Honor, we'll let this
May it please the court, Karla Perkins for the department, and Jennifer McKloone represents the child who wants to go home, MM. The case, and I'll deal with the mother first, actually, where the initial testimony from the therapist who was doing the visitation with mom and dad and the children, first they were together, but then she said that they separated. So when she was doing the visitation, it was mom separately with children, dad separately with children. Problem with mom, and the testimony here is from the case manager. But was there any evidence as to what their relationship was at the time of the TPR hearing? The trial, there actually wasn't really a clear testimony of where they were, whether they were still together. We really don't know that from the record. So I would have to agree with the court where the record is not clear on that fact. The problem, though, is you have to look at the mother. You have to look at whether, as you, Judge, indicated, whether she had gained the insight. And the fact was she was going to the mailman center because, yes, there was a problem with the early referrals. But I think it would make a difference, at least to me. I can't speak for the rest of the panel, but it would make a difference to me as to whether or not the father was going to be involved. I mean, if for argument's sake, the father's parental rights are terminated,
and the mother and the father have no continuing relationship, then it may make sense in as it relates to AM to give the mother more time to be able to gain insight that she would need, because the child would not be at risk if she was returned to the household if the mother was not having any involvement with the father.
But the court's premising, mom not being with dad versus mom learning to protect herself and her children. In other words, it doesn't have to be the father alone that the mom can get involved with domestic violence. If she chooses to move on to someone else who starts perpetrating domestic violence again, then what does she learn? The fact is, Dr. DiTomaso spoke about that. She testified to the fact where if this mother doesn't learn to protect herself, how then can she be able to protect her children? So yeah, the father is clearly a violent person based on her testimony alone that she suffered physical and verbal abuse from him, and the children were present some of the time. Now, the case is in a peculiar position where you have one child who clearly does not want to go home. That child who does not want to go home, clearly there was a problem in the home. Has the mom remedied the circumstances where that child alone would have felt safe to even go back home? She's not. The case manager testified.
There could be many reasons why a child might want to live in one particular place or another. And maybe the younger child, MN, is very happy where he is for whatever reason. But my concern is before you terminate parental rights, I mean, it's a really big step. And if you've got a mother who is going to the courses and has completed many of them and shows an interest and relates very well with the children, and you have a child who specifically is old enough to make that decision and wants to return to the mother, why not give the mother a little more time to see if she gains the insight that's necessary if the father's not in the picture anymore?
The problem with
if they're continuing to see each other and he's in the household, that's clearly a problem. That's a different scenario. But if he's gone, I think it makes a difference.
Well, I'll tell you what, though.
Because it would at least show to me, if he's gone, that she's gained some insight that he's a danger, that he's a danger to her children and that she doesn't want him to be a part of her life because he's abusive.
Yeah, but, here's the problem with the mother, though. If you look at her actual therapist, because the mom went ahead and waited until December to look for her own therapist, December of 2010. She didn't actually begin the therapy sessions until February of 2011, and Ms. Mosier was her family's therapist. And Ms. Mosier said that mom was beginning to recognize the problems of domestic violence and what to do with it. This is February of 2011. I mean, if you look back at the referrals from back in 2010, you look at the fact that the mom was going to the mainland center where she was getting the individual therapy. Yes, right. She did complete that initial time frame, but then she didn't continue.
If we reverse the termination, she's still dependent. The children are still dependent, so you can continue to supervise. And if she gets into another relationship, you can also file for termination then. I mean, I just don't see, termination is like the death sentence in a criminal case. I just don't see this being sufficient to warrant termination.
You're speaking solely about the mother, though,
right.
Not the father, correct?
Right. Who's going to address the father? Is that somebody
No, I'm
else?
going to address the father, too. I get the rest of it.
Okay, so you're the last...
I do, everyone else.
Okay.
The father clearly was a problem where, even if she didn't get to do the anger management, his counsel would argue to the court that the department didn't help by paying for the anger management courses.
But he didn't even recognize or accept the domestic violence, even though he agreed to the consent judgment of domestic violence, and the mother admitted to it initially. The children admitted. I mean, the evidence is very clear there was ongoing, continuous domestic violence in the household, and he only admitted to one argument 10 years before, so he clearly hadn't reached the stage where he was even ready to admit what the problem was. So his insight is about zero.
Okay. And so the child now who wants to go home, the court has a responsibility, yes, to listen to what the child wants, but the court has to look at the circumstances there and make the determination whether it is actually safe to put the child back home. it would be safe to put the child back home if the mother had gained the insight that's needed to learn to protect, because she has to be able to protect herself in order to protect her children also. So the court did make a valid determination that looking at the mother, even if, the mother was visiting with the children, was doing well, everything, court looked at the circumstances of the parents, looked at the mother. What has the mother learned? What has she done in terms of remedying the circumstances? Because that's what substantial compliance is. They're given a case plan and they're told, you have to be, not only complete the services, and it doesn't matter if they do part of it but not everything. The court can find along the way, okay, they've gained enough insight that we can start putting the children back with them. Eventually that leads to reunification. But there comes a point where the court has to make the determination that is the mom really engaged in her services to the point where we can put the child safely back with her. Now, if this court actually feels that the mom is more viable, the department is willing then to move for relinquishment to really seek a therapist to visit with the girl and ask for that.
Of the order terminating parental rights. How do we get into, assuming we rule on the termination of the parents, how do we address AM? I mean, is that something that we would have in front of us? We have jurisdiction, or is that part of the dependency?
The child MM, the child AM.
AM.
The child AM and her wishes to go home?
Right.
That actually would be part of the whole picture, really. So
that's what I thought.
The court can address that too, but, in essence, if the court's looking at a single parent termination...
Let's say that we reverse the termination of the mother. Do we have to then, in the order, in the opinion, address AM's wishes, or is that still something that... I mean, how do we get into that issue? Because we don't have a separate order for AM. We just have the termination.
Well, part of the thing, too, is with a single-parent termination, there has to be single-parent findings also under 39.811.6. So...
I think what Judge Ramirez is asking can we bifurcate the ruling as to AM versus the other two children? If we reverse, do we have to reverse as to all three children? If we affirm, do we have to affirm as to all three children? Or can we bifurcate one of the children out of the scenario?
But this is what I was explaining, though. We have a problem here, too, where if you're going to do a single-parent termination, there actually needs to be findings by the lower court, too. And if you're going to terminate as to one child only, it becomes even more complicated. I mean, yeah, you can.
But my question is, let's say, I'll try to ask it again better. We affirm as to the father, we reverse as to the mother, as to all three children. We don't need to address AM, correct?
Oh, okay. So you're going to reverse as to all
No, I'm not saying that that's going to happen. I mean, I'm not, one-judge panel here. I'm three-judge panel. So, assuming that we agree on that, I don't know if we will, do we need to address AM?
You would need to address AM, but you would need to address MM, who does not want to go back to the mother. The child MM, who is also old enough to articulate his wishes, he doesn't want to go home to either the mother or the father. So the problem...
Well, it's very unusual to have... I mean, if we feel that the department has not shown sufficient reasons to terminate the mother as to any of the children, then we don't need to address any particular one's wishes. Okay.
That's true. That's correct.
Thank you very much.
Thank you.
The department would ask you to affirm.
Thank you.
Judge Ramirez, if I could have 1 minute rebuttal, and Mr. Rodriguez would like 1 minute. I'd quickly like to just say, first of all, the testimony was that the mother's relationship with the children was very positive. Her interaction with the children was positive in the testimony. Moreover, her therapist testified that the mother now recognized the red flags for domestic violence. There was positive testimony as what the mother had learned regarding domestic violence by her own therapist, the individual therapist that she began with in December of 2010, not February. I believe counsel misremembers. She started in December, but it wasn't regular until the end of February, beginning of March, when she started going weekly. And lastly, to Judge Ramirez's question, and I don't know the answer about bifurcating children, but I do know there's a case on point at the lower court level that says that in CPR trials, you need to treat each child individually. And if the court wants, I'll find it and supplement the record.
Thank you.
Okay. Yeah, appreciate it.
I think the one that's more in need of a rebuttal is the father. Do you want to rebut?
I would only say that the issue with the father had to do with whether or not he was given the proper services. Now, I'm not a therapist. I don't play one on television. But supposedly the department had, quote, certified experts or whatever they call them to say, this is what this father needs in the dependency action, to heal him, to become a better parent, which is the issue in front of the dependency court.
But all of the witnesses, as it relates to the father, said he was not gaining any insight, although he had gone through much of the program, that his lack of empathy or compassion was frightening, especially with regard to his children, that he's brutal and callous and capable of harming his own children. I mean, that's pretty strong language.
Yes, Judge. And that's why he needed the last two courses, which would have brought him over. We don't know that. These are the experts. I can't be that expert. That's why they have these people to deal with domestic violence and therapy, which supposedly cure people.
Except if you don't even admit that there is domestic violence, that all you had was a verbal argument 10 years ago. That's, after going through a year of services, that's as far as he got.
As I say, we don't know because he was not allowed to have it because the department decided on its own, unilaterally, we're not going to provide him with the services. If they'd have done it, then whatever would have come out of it, and I wouldn't be making this argument now. But they didn't do it, and I am making this argument now. Thank you.
Thank you.
Thank you, counsel. Thank you, everybody.